Did you know that in the United States, there is no federal law that prohibits employers from asking candidates about their salary history? But at the same time, 17 states now have formal restrictions that limit or completely prohibit that question. That means depending on where you hire, a question like that may feel routine in one state could create legal exposure in another. Hi, I'm Taylor Maurer, founder and senior managing partner at Heavy Civil Resource Consultants, a recruitment company focused on talent acquisition for bridge and highway construction, along with related infrastructure construction and engineering projects. Now, this is becoming an important topic for contractors, construction leaders, hiring managers, especially for companies operating across multiple states. For years, one of the most common questions during the hiring was simple. It was, what are you currently making? The logic behind that question was straightforward. Employers wanted to understand whether a candidate's compensation aligned with their budget, internal pay structure, and market conditions. But lawmakers in many states began to challenge this practice because salary history can sometimes carry forward old pay inequities. If a candidate has been underpaid for years and a new employer bases an offer on that old number, the argument is that the market never really corrects itself. That's why states like California, New York, Massachusetts, and Colorado now prohibit employers from asking for salary history or using it to determine compensation in many situations. For example, in California, employers are prohibited from seeking salary history information and from relying on it when deciding what salary to offer. In New York, employers cannot ask candidates directly, and they cannot ask or contact prior employers to obtain that information. And while each state law is slightly different, the overall direction is clear. Compensation decisions are increasingly expected to be based on the value of the role, not simply what someone earned before. For heavy civil construction, this matters more than many people realize because our industry often hires across state lines. A contractor may have projects in multiple states, different offices, or mobile operations that move crews, superintendents, estimators, project managers, and engineers across jurisdictions. That means your hiring practices need consistency. Even in states where asking about salary history is still legal, many employers are choosing to move away from it anyway. Why? Well, because current salary does not always reflect current market value. A superintendent who accepts a lower package 2 years ago may now be significantly under market. An estimator may be working in a region where compensation simply lagged behind demand. And if you base your offer only on prior pay, you may undervalue strong talent or lose them entirely. A better question to ask today is, what compensation range would make this opportunity worthwhile for you? That keeps the conversation focused on expectations, role value, and market alignment. It also gives employers cleaner data to compare against internal salary structures. And for construction leaders, that matters because hiring mistakes are expensive. The wrong compensation strategy can slow hiring, create internal pay tensions, and make it harder to retain top talent. So here's the bigger question for both hiring authorities and candidates. Should a new salary be based on what somebody used to make or what the role is truly worth today? Because legally, more states are changing, but strategically, many employers are changing even faster. You can click the link below to access research that we've done regarding specific state laws on this topic here. Thanks for watching, and here's to successful hiring.